Good morning, good afternoon, and thank you for joining us today in this event where we are going to address accountability through liability for spyware abuses. This event today is part of a larger joint project between the Strategic Litigation Project and the Cyber Statecraft Initiative here at the Atlantic Council. We have some exciting reports coming up soon. They should be published in the next few weeks or throughout September, where we look at specifically how tort liability can be used to address the harms caused by spyware abuses. As part of this project, we also have a blog series in partnership with Just Security that many of our speakers here today have contributed really excellent pieces to, and we encourage you to go read them, as many of those are already live. And you can ask questions throughout the whole event through askac.org. We encourage you to identify yourself through name and affiliation if possible, and we'll answer as many of the questions as we can at the end. We have a packed event today, so I'll go straight into introducing all our speakers. My name is Lissandra Novo. I'm the Senior Law and Tech Advisor for the Atlantic Council Strategic Litigation Project, where we work to find innovative solutions to entrenched accountability problems for human rights violations and international crimes. With me alphabetically, we have Sarah Ann Brackett. She is Assistant Director with the Cyber Statecraft Initiative, part of the Atlantic Council Tech Programs. She focuses her work on open source software security, software bills of materials, software liability, and software supply chain risk management. We also have Nadine Fareed Johnson. She's the inaugural policy director of the Knight First Amendment Institute at Columbia University, where she leads the Institute's policy and advocacy efforts to advance freedoms of speech and the press in the digital age. She also teaches on speech, democracy, and the internet at Columbia School of International and Public Affairs. Next, we have Lindsay Freeman. She's the Director of Technology, Law, and Policy at the Human Rights Center at UC Berkeley School of Law. She leads the International Accountability Team, which conducts rigorous investigations, builds legal cases, and supports justice mechanisms in the pursuit of justice and accountability for cyber-enabled international crimes. Natalia Krapiva is Senior Tech Legal Counsel at the digital rights organization Access Now. She leads Access Now's efforts to strategically engage courts and legal processes to uphold digital rights and works with Access Now's Digital Security Helpline to investigate state-sponsored digital attacks against civil society, including spyware and phishing. And finally, we have Jen Roberts, Associate Director with the Cyber Statecraft Initiative, part of AC Tech Programs. She leads CSI's proliferation of offensive cyber capabilities work, including spyware. Her recent publications include Mythical Beasts and Where to Find Them, mapping the global spyware market and its threats to national security and human rights, as well as Markets Matter, a glance into the spyware industry. Welcome, and thank you all so much for joining us today. So I want to jump really straight into why this is important, why we want to talk about accountability. And the reason, of course, is the harms that engender spyware abuses. So Natalia, why don't we start with you?
Thank you so much, and thank you for having me. So I work with Access Now, we're a digital rights organization, and specifically with the helpline, our digital security helpline that assists victims of digital attacks. This includes journalists, activists, human rights defenders, and over the past 6 years or so, I have been working with victims of spyware attacks. And what I have seen is that the being targeted with these types of sophisticated attacks is really is devastating for these individuals. We see sort of a wide range of effects. There's psychological effects. There's a sense of profound insecurity, fear for themselves, for their colleagues, for their journalistic sources, if they're journalists, their loved ones and families. A sense that somehow they betrayed the trust of the people around them, even though there's nothing that they themselves have done to bring about this these attacks. Oftentimes it's impossible, especially when it comes to zero-click, so-called zero-click attacks. It's impossible to protect yourself from them. I've heard some victims say, well, it feels like I am being stripped naked in public. I feel very vulnerable. It's really this kind of profound feeling of extreme vulnerability. Professionally, financially, it affects victims. Obviously, it affects their ability to continue their work. If they're journalists, if they're lawyers, again, this trust that they have with their sources, with their clients, is being damaged, and some even are not able to repair it, and so they sometimes leave the profession. There's also a very particular sort of cost and expenses that are associated with it. You have to replace your phones, your computers. You have to have your phones, change your phone. So you kind of have to start from scratch in many ways. And that also has effect on people's ability to maintain their relationships, professional relationships, personal relationships. And lastly, obviously, these attacks do not come in a vacuum. Oftentimes, the individuals that we work with, journalists, activists, human rights lawyers, they are already facing a lot of other types of attacks, both digital and physical. So it could be harassment online, doxing, DDoS attacks on if they're journalists on their media websites. It could be physical attacks like physical attempts even of assassination. They're facing criminal persecution and being sent to jail for the work that they're doing. So it really is this kind of a profound sense of insecurity and harm that we see, unfortunately, oftentimes is not being addressed. And there is a very real need to provide redress to these victims.
Thank you so much, Natalia. It really highlights the severity of the harms and the links between the different types of harms. Lindsay, I know in your investigations you've come across something similar, if you could expand.
Yes, thank you so much for having me. And Natalia did a great job of explaining the array of different types of harms, from the direct harm to victims that come from the spying itself and the violation of human rights, to privacy and those kinds of things, as well as the more traditional harms that are often accompanying this in different ways. And that latter part of it is really where my team at the Human Rights Center at UC Berkeley is focused. We investigate core international crimes, so crimes against humanity, war crimes, genocide, and the crime of aggression. And the truth is, in all of these crimes, more and more we're seeing the use of new and emerging technologies come up to facilitate or enable these types of crimes. And I would say crimes against humanity in particular, when you have authoritarian or corrupt governments or increasingly non-state actors that are very powerful, that have a desire to repress the civilian population, intimidate them, um, just to consolidate power in many different ways. You see this type of spyware and other tools being used to facilitate that. So that could be using the geo-tracking capabilities to then identify or find people that have been killed, have been disappeared in several different countries and situations and contexts that we're looking at. And you also see, I think, from spying sort of the motive or desire drawing a target to certain journalists or human rights defenders because of the work they're doing, because of the investigations they're conducting. If somebody is unlawfully spying on them and sees they're about to publish a story or looking into something that they don't want them to, um, usually the recourse for that, or, they're um, uh, we see them carrying out actual crimes against those individuals, or the sources that journalists are talking to, or even, yeah, in different situations, we see those types of traditional harms as well.
Thank you so much. It's a good reminder as well that sometimes the use of spyware is not the goal in and of itself, right? In order to just get that information, but that information can facilitate some really grave additional harms that are compounding the damage and harms to victims. Nadine, I know your team also works on policy and sometimes as well some of these cases, if there's anything you'd like to add.
Sure. Thank you so much for having me. Natalia and Lindsay laid out a really well thought out landscape and understanding the scope of this. I just want to focus a little bit on the fact that sometimes people don't think about the impact on U.S. citizens and residents of the use of this spyware, and thinking that happens to someone else somewhere else. But in fact, U.S. citizens have been targeted with Pegasus since the earliest days of NSO Group, for example, having that product. In one story we don't hear a lot about anymore, Panama's ex-president was accused of ordering a spyware scheme targeting U.S. embassy officials, and a former deputy manager of then Senator John McCain's 2008 presidential campaign. That was several years ago. So Americans have been targeted almost since day one of this. And the arc of that targeting includes U.S. citizens who are working abroad and Americans here at home right up to the present. And I'll talk a little bit later about the litigation that is led by some of my colleagues at the Knight Institute, but that does involve an American citizen and 2 U.S. residents. And we've actually seen the targeting of U.S. lawmakers as well, with predator spyware. So just to underscore the fact that this is truly a global phenomenon and it does impact folks in the US as well.
Thank you so much. That's a really great reminder to us all that this isn't just a faraway problem and that these networks are also international in scope, and that something that is happening there should really influence how we think about policy and recourse here as well. And so I want to go on to what makes it additionally difficult to get redress for some of these abuses, in addition to how severe these harms are. The ecosystem for spyware at large is quite opaque. And this is something that our colleagues at the Cyber Statecraft Initiative are really trying to shed some transparency on. So Jen and Sarah, if you could tell us a bit about your findings through your research into really what makes the system so opaque, so difficult to track down exactly who is doing what, where, etc. That would be really great.
Thanks so much, Lysandra. And I think you hit the nail on the head. Setting out to map spyware tools landscape is not an easy task. And I would say if I'm an expert in anything, I would say that it's that. For context, I am the lead author on a report called Mythical Beasts and Where to Find Them, mapping the global spyware market and its threats to national security and human rights. And what this report does, it's a report on the global spyware market from 1992 to 2023. It surveys 435 different entities across 42 different countries that operate in the spyware market. These entities are comprised of spyware vendors, partners, suppliers, subsidiaries, branches, investors, and individuals. And what it aims to do is get a better sense of the global supply chain for spyware. I would say that there are 3 big difficulties of mapping this ecosystem that I encountered in my own research. The first, it's not easy to find information on spyware vendors. They don't like being found. And it often takes more than one source to put together a good picture, a mix and match of a variety of different information. Corporate registries, popular sources like news articles, hack and leak, data dumps, and court records are all types of sources in different languages that need to be put together to understand sort of a basic picture of vendor supply chains. And oftentimes this picture is not complete. Transaction records, pricing models, and many other important information is not available online. So the first problem being it's not easy to find information about spyware vendors. The second being a variety of different sources call spyware vendors different names. Even if you do get a good picture, it takes a really long time to get there. For example, the spyware vendor Candiru has been operational as Satiotech LDT for many, many years, but oftentimes people still call it Candiru. This makes it difficult for policymakers and researchers alike to keep track of entities that operate in the spyware market and pursue accountability for misuse accordingly. And then the third is that information disappears. articles go offline from slap lawsuits where vendors attempt to get their information scrubbed from the web. Sometimes exposing sources burns them. Hesitancy to declare where a good source might be and fear that it will be no longer available in the future is certainly something that we had to weigh when publishing our sources for the Mythical Beast report. And then also civil society organizations are hit with takedown requests. Often the organizations setting the most transparency into the space are those who get the most direct targeting from organizations who thrive under secrecy of operation and fear of exposure. So the Mythical Beast report unpacks 6 trends found in our sample of the global spyware market, finding a concentration of entities in 3 major jurisdictions, Italy, Israel, and India, that there are serial entrepreneurs across multiple vendors, that there are partnerships that exist between spyware and hardware surveillance vendors. Vendors regularly shift their identity and change names. There's evidence of strategic jurisdiction hopping and also cross-border capital flows that fuel this market. Many of these recommendations of this report call out the need for greater transparency into this ecosystem, which is also incredibly vital for accountability efforts, the subject of today's event.
Thank you so much. That's really such a great overview, and I really recommend for anyone who hasn't read the Mythical Beast report, please do so. It's really such a font of information, and it also has a public data set that you're welcome to explore and really try and make your own connections and see the data that the Mythical Beast authors were able to derive these patterns from. And this really leads into one of the major issues that we faced when we were thinking about liability, which is the fact that these practices make any kind of efforts at norms and regulations really difficult. Without policymakers really being aware of the behaviors of the actors in this ecosystem, it's quite difficult to design any kind of system that could regulate or limit their behavior. And so in this sense, you see a lot of these efforts popping up. For example, the UK and France-led Pall Mall process. This is a voluntary and non-binding process. And so while states may join this, it doesn't impose obligations on the states that sign it, and it doesn't impose obligations on the industry that it seeks to regulate. International regulatory efforts in general take many years. Treaties can take over a decade to really go from negotiation to implementation. And then even if you have regulation at the international level, many countries will need to enact domestic legislation, which can really add to the time. This leaves quite a large gap, as any of these efforts will really only apply to future behavior. And so that leaves quite a bit of impunity for past and ongoing abuses. And this is really where we think that civil and criminal liability can step in terms of accountability. We don't think that this should be the only recourse. This is really quite a large problem, and as we've highlighted, the harms are multiple, as well as the behaviors that are regulated. And so civil liability and criminal liability, which Lindsay will speak a bit more about, can really serve as a gap-filling function, especially for these past and present abuses that will be outside the scope of any future regulation or legislation. And we've seen this in some of the efforts, as Nadine mentioned. Her team is also involved in litigation. Natalia has also mentioned litigation. There have been some civil cases that have shown some promise. Notably, there's been a few cases in California, such as the WhatsApp v. NSO group case. This has been years in litigation, but a jury did award a nearly $168 million in both compensation and punitive damages. For those joining who aren't lawyers, compensation is essentially money to make you whole for costs incurred, while punitive damages, as the name implies, are meant to punish unwanted behavior. They are supposed to serve as a deterrent to similar actors to discourage them from engaging in the same kind of behavior. And so the punitive damages in that case were over 167 million. And the NSO group has appealed, so the saga is not over yet. But this shows that civil cases are indeed possible. And as Nadine mentioned, there is also a case that she'll talk a bit more about that was brought by individual victims. And this was also brought in the US, and it's in California. Now, these cases were brought on a mix of different grounds. Some of these include breach of terms of service by NSO Group, for example, breaching WhatsApp's terms of service, and also the California Computer Fraud and Abuse Act. But civil liability is quite broad in scope, and there are many bases that can be explored. And so that's what we wanted to do in this project. And so the Strategic Litigation Project team focused specifically on what's known as strict liability for ultra-hazardous activities. And we'll unpack this a bit because it's a very wonky sort of legal name. But we wanted to explore strict liability first, because strict liability imposes a lesser burden on the plaintiffs when it comes to proof. So traditionally under tort, you have to prove negligence. It's really the kind of vast majority of tort cases are under negligence, and these involve a greater number of factors showing that a defendant owed a duty to a plaintiff, that they breached that duty, that there was some kind of intent. And this can be quite a burden for a plaintiff to find the necessary evidence to prove those elements. But under strict liability, while it's still difficult, and we don't mean to imply in any way that this is an easy goal, it reduces the number of elements that plaintiffs have to meet. So essentially, you have to show that the defendant indeed caused the harm and that the harm came from the activity that is covered by the particular theory. So ultra-hazardous liability is a particular theory of strict liability that's envisioned for activities that are so inherently dangerous that any kind of preventive measures still can't eliminate the risk of this activity. Classic examples are blasting and handling explosives. And the sort of typical example within this is some kind of blasting with explosives, and a boulder falls and damages either a person or nearby property. And that person or nearby property did nothing to contribute to this chain of events, other than maybe walk by the zone, right? And so this is envisioned in this way because it really wants to ensure that those activities that are so dangerous to carry out, that an entity chooses to carry out for profit nonetheless, that those possible victims are covered by any damages resulting from carrying out these activities. So we looked at California and the UK. So we looked at California. First, tort law in the United States at the state level is different in every state. And so unfortunately, we couldn't do a 50-state survey. And so we chose California, given the number of cases that have already been brought there, as well as the fact that several companies are headquartered there whose products are routinely exploited. So for example, Apple, when an iPhone is exploited in order to use spyware against a particular person. We chose the UK because it's one of the countries involved in the Pall Mall process that's very vocal in calling for accountability, and they have a similar system to the United States. In fact, both systems of ultra-hazardous liability stem from the same original case in the UK. In California, our research showed that there is a possibility that this theory could be pursued for spyware harms. And here we also want to thank the team at Foley Hoag, who provided really invaluable research assistance as we looked into really what's possible under this theory. One thing that makes this promising in California is that there is no predetermined list of what ultra-hazardous activities are. The court selects in every single case. And so this makes it possible to present novel approaches like spyware, where it's not that traditional physical of something going wrong at a particular site, because as long as you go through the multi-factor test, that there is a possibility for the court to decide that this new activity that had been envisioned before still meets the threshold. And we won't go over all the factors here, but they will be in the report, and I do encourage anyone to read them. But these factors include the severity of the harm of the activity, the risk that that harm will actually occur, and as well as whether this activity is very dangerous or if it's more highly specialized. So for example, if it's a very common activity, it usually does not qualify for ultra hazardous activity status. But if it's a more specialized activity, like spyware, where we have these very specific companies that are engaging in this, and it's not a widely available technology, it could be much more likely to be treated with this. Um, and so we think that in California, this is promising that spyware really could meet a lot of these factors for an activity that's inherently dangerous. Our panelists really expertly laid out a lot of the harms associated with its use thus far. And these are typical uses, right? That we see that the way that it's used by some of these clients really can lead over and over and over to these compound harms. And that no preventive measures so far have been enacted to curb these harms. And so that can really also go a long way to showing the inherent risks of the activity. Unfortunately, in the UK, our research showed that while this doctrine originated there, it actually remained much more narrow in the UK. So it really is still tied to this idea from the 1800s of a substance that escapes and goes loose from a property and causes damage to a neighboring property, such as a reservoir bursting and the ensuing damage from water. Additionally, courts in the UK have been really reluctant to expand this doctrine to activities beyond this really narrow scope. So we think for the UK, it's really important to continue doing additional research to see if there are other kinds of liability that could open up additional pathways for plaintiffs to bring suit. And so, we really hope that you'll read this report in more detail. It includes a lot more explanation about the different factors, both in California and the UK, as well as a set of recommendations for victims, for policymakers, and for funders in the space. And so with that, I want to pivot to Sarah Ann and Jen so that they can walk us through some of the findings from their team on products liability.
Thank you so much for having us today, Lysandra. Jen and I have been working on a report that's a follow-up to a previous CSI report, which was titled Design Questions in the Software Liability Debate, that looked at the policy debates around software liability for software security flaws and seeks to identify how that approach of rebalancing responsibility to the best positioned actors can translate to software accountability, including through identifying existing incentives and obstacles in both California and the UK that can really affect progress towards that goal. So as Jen and Lysandra have already discussed, a lot of the same challenges to tracking and holding spyware entities accountable really affect a liability regime. One of the things that we found in our report is that awareness is really an essential prerequisite to accountability. And that's a real obstacle to litigation and also to other public accountability efforts, because by design, spyware victims are often unaware that their devices are targeted by advanced cyber capabilities. The obscurity factors that Jen talked about are also really relevant here, because spyware vendors can undergo name changes, shift their corporate structures to hide their identities, which can be to manage public backlash to businesses, but also to evade legal accountability. And that also creates challenges in finding appropriate legal avenues, as that can change jurisdictions that are appropriate. And I think, as mentioned also, spyware vendors have invoked sovereign immunity and other defenses to lawsuits to frustrate efforts to hold them accountable. Another risk that has been mentioned briefly is exposure of technical information, because litigation can draw in third parties and risk their advocacy work and research by exposing information that can be used to attribute forensically these attacks, and exposing that information publicly can allow spyware vendors to evolve their capabilities and stay ahead of advocacy organizations that are holding them accountable. But one thing that we've really found in our report is that technology companies have unique capabilities that they can use to push back against spyware's harms and risks, including insight technically into the operation of spyware campaigns across victims, and are very well positioned to block spyware's access to users as the firms that are responsible for developing and maintaining a lot of this underlying technology. And we've identified a couple kind of ways that this works and functions. The first is technical insights, including with the example of Apple's detection of NSO Group's use of iCloud servers as a part of delivering the payload of a spyware product onto end user devices. But also companies whose products aren't directly targeted by spyware have access to information and the ability to intervene against spyware vendors, including with examples like Amazon Web Services shutting down NSO Group's use of their cloud content delivery network service in 2021. Technology relationships also have technology companies also have direct relationships with users, which gives them the ability to deliver threat notifications to affected victims in a way that's distinguishable from spam or other attempts to infect devices, because technology companies can proactively communicate with affected individuals. Spyware tools also exploit vulnerabilities and misconfigurations in the software that is developed by technology companies. And chains of vulnerabilities, including zero-click exploit chains, can only be really conclusively stamped out with patches issued by the organizations that are responsible for the products and devices. And then the other kind of factor that we wanted to call attention to is the ability of these technology companies to offer additional security features, such as Apple's iOS lockdown mode, which heightens protections for victims by reducing the functionality of a device and hardening the attack surface of the ultimate device, which Apple has also included as part of its bug bounty program, and really applied financial incentives to the security research community to ensure that those that are using lockdown mode are better protected. And there are similar initiatives within other technology companies, such as Google's Advanced Protection Program, which also turns on other optional security settings. So in general, we think a lot of these factors mean that technology companies can really be some of the best positioned actors to address this problem. And so our report talks about some of the different policy mechanisms that can be used to incentivize this behavior and to reward and protect companies that have already engaged in some of these behaviors.
Thank you so much. I'm really excited to read the report when it comes out. And it's really important as well to highlight the different kinds of accountability that can be enacted by different actors. It's not always about post hoc investigations, but also really about using liability to create an incentive structure for different actors involved in the chain to adopt good practices. And with that, though, I do want to talk about some of the difficulties of liability, because we don't want to imply that this is really a panacea. This is a really difficult road for victims, for lawyers. It's extremely resource intensive, and it can really have an additional negative impact on victims who pursue these cases. So with that, I want to really go over to Natalia, who has a lot of experience in pursuing litigation and these kinds of accountability efforts.
Thank you. So, yes, I want to expand a little bit on what Sarah mentioned about the risks for companies, for civil society, for victims that are engaging in these types of litigation against spyware companies and actors. Is that there's information is being exposed. And this is one of the unique aspects of the United States legal system, particularly we're talking about civil litigation. And in other countries have it to some extent. It's called disclosure. It maybe goes by other names, but in the United States, it's quite unique because it's very broad. It's quite comprehensive. So we're talking about the discovery stage. That is before the trial, where parties are requesting from each other information that could be helpful to their respective cases at trial. And we have seen in the case of WhatsApp versus NSO, where NSO in that case has abused, I think it's fair to say, abused the system, because in fact the judge was, there was a ruling by the judge saying that the information that they requested was not relevant to the issue at hand. So they did use this process in the legal case to request information, sensitive information, both from WhatsApp as well as from third parties like the Citizen Lab, who are researchers who weren't really involved in the case, but they were, they helped WhatsApp to identify some of the victims, whether they were civil society or not, but they were not involved in the technical aspects. But nevertheless, NSO has used the discovery process to try to force out of WhatsApp and the third parties its sensitive information about the victims, who they were, try to sort of imply that the victims were somehow responsible for their own targeting because they were criminals and not civil society, not human rights actors. They also ask for information, sensitive information like research methods, indicators, again, that are helpful for researchers and companies to identify these companies' methods. And then, of course, once the companies learn about them, then they can change them and it will be impossible anymore to locate. It's like a burglar, is being sued and then asks for, to show him how exactly his methods were identified of the lockpick. So it really was a quite invasive request, and we would argue that, and it is, I think, considered that these types of requests could be considered a form of a SLAPP, a strategic lawsuit against public participation, basically retaliatory measure in response to seeking accountability. And it could be a very expensive thing to defend yourself against, because you have to figure out, okay, what kind of data do you possess? Where is it? You have to locate it, you have to prepare it, and then obviously argue some of it that you can protect, that it should be protected, and you need lawyers for that. And oftentimes, I mean, aside, Citizen Lab is a part of a university, they have and they also have ethics guidelines and so on that protect their information. But oftentimes others, if they're individual activists, if they're smaller civil society organizations, they might not have the resources, the budget, the legal framework protecting them. So it could really have sort of a chilling effect on civil society, on individuals seeking accountability. But there's also a national security, digital security aspect, right? So again, these types of methods, they are not, the information about how Apple or other companies is finding this spyware in their systems. It's valuable not just for NSO and other companies, to Israel, maybe the country that is where these companies are located, but also to adversaries like Russia, like China, like Iran, like perhaps also criminal groups that are seeking to exploit these vulnerabilities for their own purposes. And that could be, either through, again, the discovery process when it becomes a public information, or they could also target the lawyers and the parties in the case to access this information. It's extremely valuable. It's expensive. Countries and pay a lot of money for these types of indicators and this type of information. So it's really something that in my op-ed about this that was published as a part of this series is I encourage and provide recommendations to judges, to lawyers, to policymakers, to civil society and researchers, as well as to funders, to be aware of these risks, to balance for judges, to make sure that they could balance, obviously, with the defendant's fair trial rights, but also that they're aware that there is severe risks to digital security, to national security, to human rights. And for funders as well who are funding this type of work, that they're aware that it's an essential piece to also have resources for researchers and civil society to protect themselves against this kind of malicious or retaliatory action.
Thank you so much. That's really comprehensive. And I know I have definitely more questions about those recommendations, and so hopefully we can get to some of that in the Q&A. A reminder to everyone watching, you can submit your question through askac.org. There'll be a box for the question as well as a place to identify yourself. If you can send those questions in now and we'll get to them at the end. And so with that, I want to switch over to Nadine, because as well, this isn't just about case law, but it's really important to have complementary measures by different stakeholders in order to really ensure that accountability is feasible and likely and doesn't remain just a distant dream only for those with really expansive resources. Nadine?
Thank you so much. So to lay the groundwork a little bit here, the body of spyware litigation cases on behalf of individual victims is still relatively small, but it is already showing signs that plaintiffs and would-be plaintiffs face considerable procedural challenges in bringing cases in U.S. courts as well as other courts around the world. Judges have rejected attempts to hold spyware companies liable for violations of state and federal laws that prohibit hacking and unauthorized data extraction on the grounds that the spyware company lacks adequate ties to the U.S. or to particular states. We've also seen judges dismiss cases on grounds that the U.S. is not the proper forum for these cases, such that lawsuits should be brought in another non-U.S. jurisdiction instead. And you can understand why this is a concern that courts have grappled with, the question of when a case is too foreign to be heard in the U.S. with too attenuated a connection to the U.S. And on its face, this connection, or this concern, excuse me, makes sense because to date, there is no public record of a device with the U.S. country code phone number being infiltrated with Pegasus, NSO Group's product, for example. There have been no lawsuits alleging misuse of spyware on the part of a U.S. government entity. But at the same time, where a U.S. district court, that's at the federal level, lower federal level, might be inclined to point parties in spyware cases to litigate in a defendant's state of incorporation, country of incorporation, or the country in which the attacks are alleged to have taken place. The reality is that bringing such a case to fruition in those jurisdictions is highly unlikely. And so this threatens a situation in which no courts will be open to hearing these victims' cases on their merits. I mentioned earlier that the Knight Institute represents plaintiffs in a case. We represent journalists and other members of the Salvadoran news outlet El Faro in a lawsuit against NSO Group. The plaintiffs in that case were targeted with repeated Pegasus attacks, and those attacks intensified around the publication of major stories exposing criminal activity and human rights abuses by the Salvadoran government. As I mentioned earlier, the victims and the plaintiffs include a U.S. citizen and 2 U.S. residents. This case is Data versus NSO Group. And just as a procedural matter to understand where folks understand what the case is now, the district court dismissed the case on forum nonconvenience grounds in March of 2024, meaning that it believed the case was more appropriately heard in another court. The court referenced El Salvador or Israel as potential jurisdictions. The plaintiffs appealed the dismissal to the Ninth Circuit, which vacated that district court's decision and remanded the case for further consideration just last month. And this case is only one of a number of cases involving individual plaintiffs that have seen significant jurisdictional hurdles. And these hurdles, as you can see from that timeline, can mean months-long battles on procedural matters, with then spyware victims ultimately seeing their cases dismissed in court on preliminary grounds and not being able to be heard on the merits. So what can we do about this? Policymakers have an opportunity to address this fundamental imbalance and create a level playing field for spyware victims, allowing a pathway to redress. And I want to note here that we have seen bipartisan federal efforts in the United States over the past few years to limit government access to and use of mercenary spyware via procurement rules, via export controls, and these are commendable, and we think they should be continued and augmented. But those provisions, those efforts don't get to the procedural issue that we're seeing in the courts. And that's where policymakers have an additional opportunity. They can step in and make it clear through legislation that U.S. courts are the correct venue for certain of these cases. So in the U.S., anti-hacking statutes such as the Computer Fraud and Abuse Act have been held to protect against unauthorized access facilitated by invasive technologies such as spyware. And it's important to recognize that these spyware purveyors' technology gains access to individuals' phones who are targeted by exploiting vulnerabilities in U.S. companies' software and accessing those companies' services. So without extensive interaction with U.S. entities' software, services, servers, the spyware purveyors could not facilitate their access to the victim's information for their clients. So one possibility for Congress would be to codify a venue right for victims who were targeted via the exploitation of that software vulnerability. using an anti-hacking statute. Congress could, for example, amend the CFAA to clarify that the use of the software, services, or servers of US companies to develop or deliver spyware to these protected devices is sufficient to establish venue for purposes of seeking relief in a US court. And the goal would be essentially to create a provision that would serve as a guide for courts insofar as venue is concerned. Plaintiffs would still need to demonstrate a sufficient connection between the spyware attacks, the spyware purveyor, the US forum, but this provision would be a guide for courts and would also, I think really importantly, signal Congress's continuing recognition of the threat posed by the unchecked use of this technology. Because ultimately, if there is no jurisdiction in which these cases can be heard, then what we are saying is that these attacks can go on unchecked and we're not going to see the accountability that needs to happen.
Thank you so much. I think that's such an important point, and it's a difficult one to grapple with as well, and something that many states are really trying to figure out is really what is their jurisdiction over cyber activities? How much of their territory has to be involved? How much of it of their nationals have to be involved for something that is not as clean cut as a physical activity that can take place in one jurisdiction and even finish in another. And so I think that's really important for us to have these innovative recommendations to try and bring some clarity to the subject. And so with that, I want to switch off to Lindsay to really round us out on kind of the international perspective on this and really what the criminal liability component can be. As we said in the beginning, while our project really focuses on civil liability, we don't think that should be the only method that is pursued. This is really a large problem that requires a comprehensive approach. And so I want to turn to Lindsay to really kind of expand on that for us.
Thank you so much. And our focus at Berkeley is really on international criminal law, which admittedly is very, very narrow in scope. So I'm not going to be talking about criminal liability in domestic courts, even though that exists and that is an avenue. But we're talking about individual criminal responsibility for particularly grave crimes. So this is not going to be the vast number of incidents. It's not going to be something that's coming up all the time, but it's going to be really focused on the most severe circumstances. The other way we are trying to fill a gap so that we are working together with others in the space. Obviously, you've heard a lot of people are focused on supply side of looking at the commercial vendors, the people who are selling or creating the spyware, where we're more focused on the demand or the clients that are abusing it as the primary focus of really showing that abuse and the very concrete harms that come about with that. And only to the degree that suppliers are complicit in that will we look at them. And there are situations where you have some of these vendors that have sold to bad actors who have abused it. It has come out publicly that they have abused the spyware and they continue to sell it. As Jen mentioned, there are these serial entrepreneurs. So there are situations where, while company names have changed, you can trace back to 2011, the same individuals playing a role in facilitating the sale of these products to the same governments that are known to have abused it. And at a certain stage, they clearly have the knowledge that it's not being used for legitimate national security or law enforcement purposes. And so without getting into too many specifics, just to give like a more concrete example where you might see this is there are situations in which historical military dictatorships or governments with some authoritarian tendencies have had their military procure this spyware, and in countries where the military has no legitimate or lawful means to spy on their own civilians, they are using those licenses to spy on their own civilians when there is no legal authority to do so. That's sort of a clear-cut case. And this has come up in situations where the use of this spyware is not existing in a vacuum, but is part of a broader course of conduct in which there are multiple different acts of repression. So for human rights groups or journalists that might be investigating abuses by a military, we're sort of looking at the situation where there's a lot of rhetoric, sort of promoting attacks on journalists and human rights defenders. There is actual violence against these journalists and human rights defenders, and there's impunity, both systematically under the law and just in practice because of intimidation, where the murder or disappearance of these journalists and human rights defenders are not being investigated. And there are countries where the crime solve rate is like 90 or 95% of the crimes go unsolved. So we're really focused on those situations where the abuse is quite severe, because our goal is to sort of build something that could potentially be an international criminal case. So we're looking at the authority under the Rome Statute, which established the International Criminal Court, but it's not just limited to the International Criminal Court. The Rome Statute really established a system where the 125 state parties to the treaty also in their domestic laws have incorporated the Rome Statute crimes into them. And in many of those countries, they have something called universal jurisdiction, where when crimes are so severe and against sort of all of humanity, or there's a certain interest where it raises to a threshold, you can pursue these types of cases in any jurisdiction. And so we're looking at avenues of universal jurisdiction where these cases could be tried. But right now, we're really focused on showing with evidence, with a significant amount of evidence, which, as sort of you guys pointed out earlier, is not easy. There is a lot of opacity around this. But really building the case that shows the clear-cut examples of where this abuse is happening and that people involved have knowledge of what's happening, and where there are really very real victims that need recourse in this. So the idea is that one big case, if we can build that, will have a strong ripple effect, because violating a wiretap law is one thing, being complicit in crimes against humanity is another, that, will have a very big impact if we can create that deterrent effect. So that's what we're working on now. And again, it's a narrow focus, but it's really meant to complement all these other efforts that are going on right now.
Thank you so much. And I think, as you mentioned, it's a really good point that this is a whole system that's been built around international criminal accountability. And it's important to also recommend these avenues that exist that weren't initially thought of to target cyber activity. They are there and they are available. It doesn't have to be a computer fraud and abuse case, right? We can really think about the different elements of this conduct and the harms that are enacted to see what existing avenues could be applicable in these cases. So I want to thank all our speakers, and we'll move on to question and answer now. We have a question from Jennifer Brody from Freedom House that wants to know what kind of additional information is needed to look into tort liability in the UK, and when we would anticipate pursuing product liability litigation. So the additional information that I was referring to earlier is really that from our research, we don't think ultra-hazardous liability would be a good basis for a case in the UK, given how the doctrine has developed specifically. And so what we encourage is other researchers to look at different kinds of tort liability in the UK. So this can entail going through case law to see what other avenues that do exist under the tort system in the UK could be viable, whether that's under a negligence theory or a strict liability theory, but to really encourage that kind of research. Because, and this goes in part to the second half of that question, that we ourselves at the Strategic Litigation Project are not currently pursuing litigation, right? Litigation really has to be a victim-centered approach when it's appropriate for a particular set of victims, given their independent circumstances, the resources available, the kind of funding scope that they have, and a risk assessment that they have to do individually. Our goal really was to reduce some of the burden in this kind of risk assessment for victims that are interested in pursuing liability, to either open or close off a door and reduce the kind of initial scoping research that is necessary so that it's an easier decision to make about whether to pursue an existing theory, especially some of these that are untested. There have been no cases looking into ultra-hazardous liability. And so that would really be an experimental case. And so what we wanted to do was get the information out there so that if someone feels that that's an appropriate test case for them, they could pursue it. So we have another question as well for Jen from CSI, just to see if you can speak more about some of the behaviors that spyware companies adopt to that make it difficult to really kind of track down their actions and even where they're kind of operating from.
Sure. Sure. So in our Mythical Beasts report, we observed sort of 6 trends in the global spyware market, and I would direct whoever asked this question to particularly 2 trends within that report that sort of get at how vendors sort of particularly obfuscate or make it more difficult for to basically to avoid accountability. Those trends would be shifting vendor identities as well as strategic jurisdiction hopping. So shifting vendor identities, I talked a little bit about this in my remarks earlier, is where vendors change their legal name, which makes it difficult for researchers and policymakers to sort of keep track of who they are procuring spyware from or who these companies are. Sometimes they also sort of shift their corporate structure, basically to obfuscate their identity or potentially manage the impact of negative press reporting to sort of circumvent some accountability. And then the second is strategic jurisdiction hopping. This is where vendors appear to have constructed a subsidiary, a branch, or a partner relationship in key jurisdictions to basically, in some cases, get around export controls. We know from a court case between a spyware vendor called Quadream that they established a company in Cyprus called InReach to basically bypass export controls in the EU. And this is something that we see sort of across the ecosystem. So I would say that the 2 big ways that this occurs is through name changing and corporate structure shifting, as well as the establishment of certain business operations in key jurisdictions.
Excellent. Thank you so much. And we'll have one last question from Paul Friedel. Does civil liability under common law require the violation of specific legal interests or legal rights, e.g. property, and how does this influence litigation strategies? I'll start off, but I also want to give our panelists a chance to answer this question as we have a lot of litigation expertise. Usually for civil liability, there is a requirement that the harm that occurs violates a legally protected interest. But this can be really, really broad. And there's a case for ultra-hazardous activity. I forget the state. I think it might have been well, I won't say the state because I don't remember off the top of my head, but essentially toxic chemicals were dumped into a swimming area in a public park, and a person sued because his right to enjoy that particular park was violated by the harm of this toxic waste. So it really, yes, but it doesn't have to be like a prescribed list. You usually just need to identify what you had a reasonable expectation of enjoying and how that was harmed. Natalia and Nadine, I don't know if you want to jump in on this one as well. No? All right. Then we'll leave it there. And I want to thank all of our panelists for joining today. This was a really great conversation. I feel like I learned a lot, and I'm really excited to read the upcoming reports, and a reminder that the Just Security series is already live, so you can read some of these pieces by our excellent panelists, and the reports will be out soon. And the Mythical Beast is also already out since last year. So with that, thank you everyone so much, and have a wonderful day.